Hello, how are you doing? Hope you're doing, hope you're fine. Welcome to Lawyers Info Hub. It's a pleasure to always have you here. Welcome, welcome, welcome. If you are new to this channel, please do hit the subscribe button, share the video. Someone wants to learn something from this content I'm creating today. For my returning subscribers, I really appreciate you. Thank you for always supporting me. Thank you for always stopping by to check what is new on the channel. We are growing gradually, and I'm proud of where we are today. So, today we're looking at how to conduct examination in chief in matrimonial proceeding. Have you been briefed by someone who wants to go through divorce, to want to go through issues of judicial separation, issues of taxation of marriage, and all of that? Then you need not worry because we got you covered. You're going to learn how to go about the trial process, how to examine your witness in chief. Now, in matrimonial proceedings, which is divorce, not commonly known as divorce, even though it entails a lot. You have the petitioner, you have the respondent, and the respondent can choose to cross petition, wherein he becomes the cross petitioner, and the petitioner becomes the respondent. And once processes have been exchanged, the respondent can file his answer to the petition, while the petitioner files a reply to the answer. And where there are children of the marriage, where there are issues of properties, the other ancillary issues to discuss. The court is always quick to send parties to meet, that is a compulsory conference where parties meet to sort out issues of custody, maintenance issue, money matters. When parties sit down to agree on these things, it makes it easier for the court to, just give consent to what they have discussed or they have agreed to do for themselves. Sometimes where properties are involved, the man or the woman, depending on who is involved, can choose to let go of one property or two properties and take the remaining, or make payment in lieu of the property. So either way, these are issues to be discussed in the compulsory conference as to who takes care of the children. Even if you're going to take full custody, do I have rights of access? These are issues to be discussed. At what point do the children come to spend holiday with me, or do they just spend holiday with you? Why they live with me? These are issues parties discuss during compulsory conference. You see, when parties are going through issues of dissolution of marriage, separation, is not an easy thing. It's emotional, it's psychological, and as counsel involved, you must do your due diligence. You must be able to put your acts together to guide these parties, even though your party is also involved. Yeah, you're for one party, but both counsels, in if both parties are represented by counsel, must, as ministers in the temple of justice, guide them aright. Most lawyers are fond of even causing more problem. It ought not to be. As much as you're representing your clients, you must also factor in the interests of the children, a lot of things in trying to represent your clients, so that at the end of it all, both parties can go peacefully. If they are separated, they separate peacefully without, you know, um, you know, certain things, or impeditions, or things that will kind of make them always regret the process, or make them regret even briefing you as counsel. Yes. So how do you go through trial? Now, when you have filed your originating process, which is the petition, and the other party have responded, peradventure is an undefended. What you do is to file for request to set the matter down for trial. File your statutory forms, and the court will, note, will give this. So if you are for the petitioner, you put in your witness, and he leads him in evidence. So the basic thing you need to know is that I always advise counsel, try to do your pre-trial before you go to court. Many people have never been to court in their lifetime, and maybe that could be the only time they will ever be in court. So do your pre-trial, sit down with your witness, discuss this whole process with them, so that it will not be new to them, so that it will not be something when they come to court, they'll just be, stammering and structuring a speech, it ought not to be. So make them familiar with the environment, the conversation, so that it will be like what they are doing a rehearsal. Yes. So you ask to start with the introductory questions, which is, please, madam, ask, can you tell the court your name? Remember, before even you start, the registrars of court must have done the issue of um, affirmation or swearing, either with the Bible or the Holy Quran. Yes, depending on the faith of the witness. Then you start. Please tell the court your name. It could be the man or the woman. Please, sir, please, ma, tell the court your name, address, and occupation. It says, my name is this. I live at this place. My occupation is this. I'm a business person. I'm this, I'm that. Now, you now ask the person or your witness, do you know the respondent? It's very important, this question. Many people miss it. Do you know the respondent? Say, yes, the respondent is my husband. We have seen instances where people file petitions with different names. Maybe because the woman has left, or because he has just gone to change name without the proper dissolution. It does not work. So their names must be the same in terms of the spouse. So you ask the person, who do you know the respondent? Say, yes, he's my husband. Then, when did you get married to the respondent? Yes. So the question will be, when did you get married to the respondent? Say, okay, I got married to the respondent on the 10th day of June 2000. Okay, say, okay, where? You state the place, at the registry, at the local government, uh, okay, so, okay. Were you given any certificate in confirmation of this marriage? Say, yes, I was issued a marriage certificate. So if you sample your witness, sorry for the network glitch. If, for example, your witness, who is maybe the petitioner, is not with the original marriage certificate, what you do is to go to the registry where the marriage was conducted and apply for certified true copy. It's very important, so that the issues of objection being raised, or the marriage certificate not being tendered will not arise. So if this is not the original, the only accepted version to be tendered is a certified true copy. Now you show the marriage certificate, the witness confirms the marriage certificate, and you seek to tender, my lord, I seek to tender this marriage certificate in evidence with respect to this suit. The court will, if there are no objection, will admit the marriage certificate in evidence and mark it accordingly, exhibits whatever the court chooses to, you know, mark it. You can also ask, what was your surname before the marriage? The person will state. You can also ask, after the marriage, where did you live with the respondent? This is where you state, I lived with the respondent at number so so so. If maybe they have moved 3 places, or they lived in 1 place or 2 places, this is where the witness will state the places they live, periods and periods they live there. And we lived at number 1 Coca Street between November 2020 to November 2021. So the periods it's very important. So as you're stating the places they are live, just so they will state the periods. Now you ask a very important, when did cohabitation cease between you and the respondent? This means, when did you people stop living together? This is where you now state, we stopped living together on this that day of that. So what led, okay, to this? Or you can also ask this question, depending on the way I ask question might be different from the way you do, but the idea is you understanding how to do it. Now you can also ask the witness, please describe your marriage with the respondent. What was it like? This is where the person will start stating the story of how the marriage was troublesome, was unhealth for him or her, state the problems that led. Now, you as counsel must know the storyline. When you know the storyline, it helps you. But adventure, the judge is not writing fast. It's a slow writer, or the judge is not even in a good mood to take long stories. It will help you know the right stories, the right part of the story that is necessary to prove your case. You're there to prove your case. You don't need to state what happened in 80s. You don't need to state summary of what has happened, and you hit the nail on the head. So while the witness is stating the story, you know the story. So you can be raising, be asking questions. Okay, what happened after then? What happened? Okay, when he did this, did you report? So you must be leading the witness right. Now, if there are issues of reconciliation as part the um, moves to reconcile. Yes, we went to our pastor, we went to our parents. My parents were reported, they came for meeting. These are stories you lead the witness to state those stories. Now, if there's issue of adultery in the petition, now and you are on the other side, you have to also lead your witness to debunk those things. If there are issues of neglect, if there are issues of violence, if there are issues, those main issues, the grounds upon which you're bringing your petition, lead your witness to expand on those grounds. Very important, so that to be obvious. Yes, let me put it like that, so that it will be what obvious. Now, the what was the last straw that broke the camel's back? You need to ask questions to lead the what now happened that led to that the separation, the living apart. It's very what then if you know the date, you can say cast your mind to the 12th day of March. What happened on that day? This is where the witness now stated, this is when he beat me, threw me out, this is where he left the house, this is where what really happened, this is where you state it. Now, it's also very important to also note if there are children in the marriage. We ask questions: is there any child of the marriage? Say, yeah, there are two children. What are their names? What is their sex? And when were they born? They state all those details. It's very important. Now, who has been living with the children? Say the children are with me. Okay, who have been taking care of the children? You state all those ones. Who have been taking care of the school fees of the children? The witness will state if there are receipts to show that they've been the one paying school fees. This is where you tender it. If there are receipts to show hospital bills, then this is where you tender it. You now ask, has there been any arrangement between you and the respondent as to the custody? This is now plays out with what was discussed at the compulsory conference. If parties have agreed as to yes, to take custody while he has unrestricted visitation right, or he has a restricted visitation right, or we have agreed that the children will spend the holiday with me, Easter holiday, while they spend the Christmas holiday with him. Whatever arrangement, or in terms of properties and all of that, you state it there too. Now, has there been any previous proceedings between you and the respondent? Was there any connivance, collusion between you and the respondent in bringing up this matter? The answer is what no, because there ought not to be any connivance or collusion. Now, for example, the issue of adultery comes up in the petition or in the cross petition. This is now where it says, are you having an affair with so the person that was mentioned? Okay, who is the person to you? Do you know the person? You ask questions to what debunk all that. Now ask the question as to what do you want this honorable court to do for you. Now remember that if they're also prevention, we're talking of issue of violence, and there are pictures you took when the person battered you, assaulted you, you must also ask questions to lead to that so that you can tender those pictures. I remember the pictures, you must know the form within which there is a computer generated evidence and all of that. So all that must be satisfied so that issues of objection will not arise. Then you ask the question, um, what do you want the honorable God to do for you? This is where the witness states what he or she wants the court to do for me. Dissolve the marriage. I want this I want a maintenance right. I want maintenance to be paid, maintenance rights. Yes, I want my children to be taken care of. I need accommodation. I want him to provide accommodation. I want him to take care of the children, this, that, or if there are properties, I want based agreement. I want the two properties so I can use to take care of my life, to get myself together. Whatever it is that the witness wants the court to do for him or her, this is where you now state it. And that ends the examination in chief. Then the cross-examination will start. And another video, I will uh, do a video on how to do cross-examination. But for today, we're limited to examination in chief. This is where you prove your case. This is where you tell your story. This is where you don't want to go and be beating around. See, some judges do not have time. They just ask you what really happened. They just say in 3 minutes, can you tell me what is the problem? You just summarize it, you know. So you must also teach your witness how to summarize. Peradventure, the judge is not the one that has patience to listen to long stories. Because in matrimonial proceedings, the rules are clear. What should be proved, what should not be proved. Once these elements are there, the marriage has broken down irretrievably. So sometimes you have complex divorce matters, sometimes you have simple ones undefended, whichever you find yourself. This examination in chief procedure will help you so that your witness gives his or her evidence and you proceed to cross examination. I know this channel is poised to helping you become a better advocate, a better lawyer in whatever you're doing, having confidence in what you're doing. One thing is very important: the confidence you have in yourself to know what you have to do and do it well. If you have any question, please drop it on the comment section. We will respond to it. If you're yet to subscribe, let hit the subscribe button and share this video. Someone needs to hear what we have discussed today. Do take care of yourself and know that you can always be the best. Do not be weary, do not be tired. Even if you're putting in effort, you're not seeing the effort. Keep putting in effort. Yeah, bye bye. Take care.